All right. So let's take a quick break from the Trump trials to do something a bit lighter. Let's talk about abortion again. So, it wasn't that long ago that I did a video on the EEOC, the Equal Employment Opportunity Commission, updating their laws around pregnancy and what employers have to give what's the word? They have to give pregnant people some accommodations, because let's face it, your body is changing and you have to deal with it. So of course there are Republican states who are now going after the EEOC because, God forbid, abortion would be one of those issues that employers have to accommodate pregnant people for, pregnant women mostly, because, I don't know, do they think that once you give birth that suddenly you don't need to accommodate them anymore? Because the result is the same. There is no pregnancy anymore. Seriously, I haven't read this article yet, but I would love to see what exactly the Republicans claim is so horrid that employers have to accommodate people for it. I'm sure it's going to be something stupid. But anyway, let's get right to the article. This week, attorney generals from 17 Republican-led states sued the Equal Employment Opportunity Commission over something they say is an abortion accommodation mandate. My first response is, yeah, and? What's the problem? Here are 4 things to know about the latest battle in the war over abortion between Republican-led states and the Biden administration. Okay, point 1. The law in question is about protections for pregnant workers, which makes perfect sense. First, a little background. In 2015, a survey found that nearly 1 in 4 women went back to work just 2 weeks after giving birth. It took about 10 years for a bill protecting pregnant workers to get through Congress, and in 2022, not long after Roe v. Wade was overturned, the Pregnant Workers Fairness Act passed with bipartisan support. Wow, back then already, Republicans still pretended to give a crap about pregnant women? Wow. That seems like so long ago. The law requires employers with at least 15 employees to accommodate workers who are pregnant with things like extra bathroom breaks, time off for prenatal appointments, a chair for sitting during a shift. It also says employers have to accommodate workers after they give birth. Well, that answers that question. I'm surprised that Republicans don't have a problem with that part either. Anyway, even though lawmakers from both parties think pregnancy protections are a good thing, abortion politics have overshadowed the news of those new rights. It all comes down to one line in the law and the word abortion in the regulation. And of course, Republicans have to have a problem with it because they don't recognize abortion for what it is. So, the law says employers should make reasonable accommodations for pregnant workers during and after pregnancy, childbirth, and related medical conditions. This new rule EEOC put out to implement the law includes abortion in a lengthy list of related medical conditions, along with everything from ectopic pregnancy to anxiety to varicose veins, which, again, makes sense because This abortion isn't something that you just go through and you're fine immediately. That's not what abortion is. I know that there are plenty of Republicans who seem to think that women gleefully have an abortion and then, party right afterwards because it's not like it's a medical procedure or anything. And they are so caught up in that they just can't accept that that's not the way it works. Actually, I'm surprised they didn't go after ectopic pregnancy, since there are some bozos who seem to think that they can be reimplanted into the uterus. Or maybe they just figure that because it can be, that constitutes a legit reason or something. I don't know. Abortion entered the chat, and about 100,000 people chimed in on the regulations. That's point number 2. Political and religious groups that oppose abortion rights took notice of the inclusion of abortion in the list of related medical conditions, as did the lead Republican co-sponsor of the law, Senator Bill Cassidy of Louisiana. Some 54,000 people commented on the proposed rule, objecting to the inclusion of abortion, according to the EEOC's analysis in the final rule, while 40,000 people commented in support of abortion's inclusion. More people spoke against it. That's not good. The agency noted that most of these were nearly identical form comments driven by advocacy groups. So I don't know if they're talking about the anti or the pro. Not sure, or maybe both. In the end, abortion remained on the list. In its analysis, the agency explained that abortion's inclusion is consistent with long-standing interpretation of civil rights law and courts' rulings. In the final rule, the EEOC says the law does not require any employee to have or not to have an abortion. The fact that has to be clarified is just downright frightening as to what people think happens. Does not require taxpayers to pay for any abortions, and does not compel healthcare providers to provide any abortions. The rule also notes that unpaid time off for appointments is the most likely accommodation that would be sought by workers having abortions. And considering it is a medical procedure, they might want time off to recover as well, I would think. Because, it's a medical procedure. Most people do not just bounce back from that. Hell, colonoscopies are supposed to be simple things. I don't bounce back from that. The lawsuit, point number 3. The lawsuit plus politics of the lawsuit. Within days of the rule being published in the Federal Register, a coalition of 17 Republican-led states filed suit, because of course they did. The implications of mandating abortion accommodations are immense. Covered employers would be required to support and devote resources, including by providing extra leave time, to assist employees' decisions to terminate fetal life, the lawsuit reads. Okay, and the problem with that is what? The lawsuit was filed on Thursday in federal court in eastern Arkansas. The plaintiffs asked the court to put on hold on the effective date of the final rule pending judicial review, and to temporarily block the enforcement of and ultimately vacate the rules abortion accommodation mandate. Arkansas and Tennessee are the two states leading the lawsuit. In a statement, Arkansas Attorney General Tim Griffin said, "This is yet another attempt by the Biden administration to force through administrative fiat what it cannot get passed through Congress." No, this isn't a way to legalize abortion. in your state. It's just saying that if the woman had an abortion, you need to accommodate that. Because, I mean, especially in the case of someone having to leave the state because you're a bunch of Neanderthals, and I think I just insulted Neanderthals, that you don't care what happens to women. This is just saying, well, you gotta kind of care. You gotta at least pretend that you give a shit about women. So anyway, Griffin said the rule is a radical interpretation of the new pregnancy protection law that would leave employers subject to federal lawsuits if they don't give employees time off for abortions, even if abortions are illegal in those states. Again, that's more reason to allow them for time off because they have to go to another frickin' state to get it. The PWFA was meant to protect pregnancies, not end them, he said. Quick point. This law specifically says after childbirth. That's ending a pregnancy. Granted, that's what you would consider the objective, the way to end a pregnancy, and in most circumstances that is the end conclusion. That is how you are supposed to end a pregnancy. But you're still supposed to accommodate women after childbirth, which means after the pregnancy has ended. So let's just say it for what it is. It's not that you're having a problem with helping women after their pregnancy has ended. It's just how it was ended. Women's advocates see the politics of the lawsuit as well. It's no coincidence that this organized partisan effort is occurring in states that have some of the highest maternal mortality rates in the country. Jocelyn Fry of the National Partnership for Women and Families wrote in a statement. Oh, so they actually do not care about women. So, yeah, I was right before. They don't want people to be forced to pretend they care about women. Okay, thanks for the clarification. Any attempt to dismantle these protections will have serious consequences for women's health, working families, and the ability for women to thrive in the workplace. Well, you've just established that they don't actually care about women, so there is that. Greer Donnelly is a law professor at the University of Pittsburgh who submitted a comment on the proposed regulation defending the inclusion of abortion. She points out that this is the latest in a string of legal challenges from anti-abortion groups fighting in the Biden administration's efforts to protect abortion using federal agencies. I really hate the term anti-abortion because there's nobody who's pro-abortion. As I said, maybe anti-natalists. But generally, people who are pro-choice are not pro-abortion. They hate it with a passion. They just understand that sometimes people have to have them. And they're not going to stop you just because they think it's icky. They know that there are legit reasons for it. So, there you go. You can really see this in a suite of abortion lawsuits, including the two that were heard in the Supreme Court this term, one involving the FDA's regulation of mifepristone and one involving the Biden administration's interpretation of EMTALA, she observes, and guesses a legal challenge will also come in response to the newly announced privacy protections for patients who've had abortions. You have a Supreme Court that is overwhelmingly anti-abortion, overwhelmingly anti-administrative state. Those two things in tandem are not a good thing for the Biden administration. Now, just to go on a bit of a tangent, even in the Idaho case, which I assume is what this is in reference to, Amy Coney Barrett is alarmed at how Idaho thinks so little of women and them having to need emergency care. Because like most forced birthers, she did not think this through and kind of forgot the part about how women and doctors know better about what situations arise in a pregnancy than you do. Just because your pregnancies were smooth sailing doesn't mean others are, and there are emergency situations. And when she became aware of it, she became alarmed that this allowed for it. So, hopefully that extends to abortion in general, that you'll now realize why abortion care is necessary. But something tells me she might have the attention span of a goldfish and will completely forget about it after this case is done. All right, tangent over for now. Point number 4. In the meantime, pregnant workers have new rights. At the moment, until a judge says otherwise, the new protections for pregnant workers are already in effect. The EEOC has a guide for pregnant workers about their new rights under the law and how to file charges against their employers. It's also holding trainings for human resource professionals on how to comply with the law. Complaints have already started to roll in. In this statement to NPR, which is where this article is from, the EEOC spokesperson Victor Chen wrote that in the first 3 months that the law was in effect, the agency received nearly 200 charges alleging a violation of the Pregnant Workers Fairness Act, which works out to nearly 2 a day. And that's where the article ends. And it doesn't surprise me. I mean, this is a culture where it was, I think, still in the 70s, where a woman could get fired simply for being pregnant. So it doesn't surprise me that there are still violations going on. I mean, there are people, for God's sakes, we have people who should know better in Congress thinking, like I mentioned before, that ectopic pregnancies you can just implant into the uterus. So these are not smart people. So, of course, if the powers that be think that, there are plenty of people who have no concept of pregnancy who probably believe this crap and so don't think that pregnant women need to be accommodated. They still think of the hunter-gatherers times when women, just squatted, had the kid, and then went about their business and continued on working in the fields. Now, whether that actually happened is a different story. I mean, it could have been that they were forced, but that it wasn't good for the woman. So, and for the baby, to be honest. So, yeah. So this does not surprise me one bit that there are violations to this act. And the fact that, again, that it's Republican-led states where maternal mortality rate is high already shows how little they care about women to begin with, pregnant or otherwise. Because let's face it, this isn't about, motherhood is so beautiful and all women should be mothers and blah, 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 blah. This is about how much people disdain women for being women. There is complete disdain for women. Not just pregnant, not just single and pregnant women. Women in general. For some reason, there is this incel culture, this incel energy that drives people to absolutely despise women. And I don't know why. Because, I mean, I honestly do not know. Is it because they wouldn't date you if you were the last man on earth? Is it because you resent women because of something that happened in your past? I mean, seriously, why do so many people, and they happen to mostly be Republicans, hate women so much? And then when you call them on, they're like, "Oh, I respect women." Really? Then why do you have a problem with them, doing what's best for them? Why does that bother you? So, anyway, that is all I have for this article. And with that, I will see you guys in the next video.